The legal fight that could completely change NASCAR's business model is now heading straight for trial. After 2 long, hard days of talks ordered by a judge, racing teams 23XI Racing and Front Row Motorsports failed to reach an agreement with the league itself. This means the antitrust lawsuit, which claims NASCAR acts like a monopoly, will go to a federal courtroom on December 1st. The lawsuit, challenging the charter system. At the heart of this major dispute is NASCAR's charter system. Introduced in 2016, a charter is essentially a franchise license. Teams that own one of the 36 available charters get a guaranteed spot in every race and, most importantly, a fixed share of the league's money. For team owners, this charter is the foundation of their business in the sport. The legal trouble started in September 2024 when the old charter agreements were about to end. NASCAR presented the teams with a final, take-it-or-leave-it offer for an extension. While 13 of the 15 charter-holding teams signed the deal, 23XI and Front Row flat-out refused. Instead, they took the dramatic step of suing NASCAR and its chairman, Jim France, the following month. The teams argue that NASCAR has too much power and control over the sport. They claim this structure limits their ability to negotiate fair deals, controls too much of the key revenue, and makes it difficult for new owners to join the sport. By going to court, the teams are trying to break what they see as an unfair chokehold on the business side of racing. A legal battle with big names. The presence of big names shows just how serious this dispute is. Michael Jordan, one of the world's most famous athletes and businessmen, co-owns 23XI Racing. His involvement has brought massive public attention to a fight that might otherwise be seen as just a contract problem. Jordan was not simply an observer during the failed mediation. He was directly involved in the closed-door discussions. Joining him was Denny Hamlin, his co-owner and an active driver in the Cup Series. Hamlin's dual role as both a driver and a team boss gives him a unique view of the issues both on and off the track. Their presence alongside NASCAR's top leaders, like Steve Phelps and Mike Helton, confirms that everyone views this legal challenge as a defining moment for the sport. The drivers step in. In a surprising turn of events, the Drivers' Advisory Council, DAC, which is led by former driver Jeff Burton, also entered the legal picture. The DAC asked the court for permission to file a brief, a document meant to provide the court with an independent, third-party view. Their main worry is that any settlement between the teams and NASCAR might end up hurting the rights and influence of the drivers themselves. The DAC insists that any final agreement must protect the long-term interests of drivers, make sure they have their own collective voice, and keep the fan experience as the top priority. What happens next? The threat to NASCAR's model. With the mediation attempts now officially over, the case is moving quickly toward the December 1st trial date. While a settlement is still technically possible right before or even during the trial, the lack of progress suggests neither side is ready to compromise. Legal experts believe this lawsuit goes beyond just the charter system. It challenges the league's entire business model. If the court agrees with 23XI and Front Row that NASCAR has been acting like a monopoly, it could force the league to completely rewrite its rulebook. This might include changing how teams are paid and how revenue is shared, giving teams more control and say in how the league is run, increased legal scrutiny over other sports franchises. No matter who wins, the general agreement is that the sport of NASCAR will never be the same after this legal battle concludes.